Welcome back. The saying goes, when life gives you lemons, make lemonade. But that is not easy to do when the lemon is your new car that you paid big bucks for. But there are laws in place to protect consumers. And today's Injuries Are Personal. Attorney Carl Reynolds from Carl Reynolds Law is here to explain Florida's lemon law. Okay, this is important because a car is a big investment. So obviously the irritation factor when there are problems is big as well.
Right.
What is Florida's lemon law?
Well, you know, and we don't mean to disparage the lemon industry here, but call it lemon law, lemon growers out there and lemonade makers, but it's a term for a car that's simply defective. And the law has protection in place for consumers to determine when a car is basically defective and therefore needs to be reimbursed by the manufacturer or replaced. So it's really three main areas that determines whether a car is a lemon. One is if it affects the use of a vehicle, something like a bad transmission, or if you have a truck that has four-wheel drive, the four-wheel drive never works. One is the value of a new vehicle. It could be premature rusting issues and things that can't be corrected. And then the other is the safety issue, if it affects the safety of the car. So if the airbag's defective, if the ABS system doesn't work proper, or the tire pressure gauges don't work.
Okay, so I have a new car, I bring it home, I'm all happy about it. Where is my window of time where problems start to show up that I could legitimately have a lemon on my hands?
Great question. We have what's called a statute of limitations in Florida that applies to all legal claims. For a majority of what I do, which is personal injury, that statute is 4 years. For a lemon law issue, it's 24 months, 2 years.
2 years.
Correct.
Okay.
So that problem has to surface and have to be an opportunity to be corrected within that 24-month period.
Okay, so that was my next question. So the problem surfaces, I'm in my 24-month period, I think, okay, you know, we may have a legal problem here. Now, what do I do as the consumer as the first steps? Do I contact the dealer? Do I try to contact a manufacturer? What do I do?
Yes. So here's how it works. When the problem surfaces within that 24 months, you need to document the problem first of all. You need to get it, take it into the dealer. And there's two main areas the way lemon law applies. Okay. One is if the same issue has been brought into the dealership 3 times and still isn't fixed. So it's a three-strike rule and you're out. Yes.
Yep.
The other one is if it's been out of service for 15 consecutive days. Okay, so if the issue could not be fixed and you've been without the use of your new vehicle that you spent big money for and all excited for, if you're without the use of it for 15 days, well then it now is subject to the lemon law. So what happens at that point is you have to put the manufacturer on notice. It's a specific form. You can download the form, and I can give the website here in a second.
Okay. All right, so which cars apply? Every brand new car? A used car if it still has a warranty under it? Like any of us that buy those 1-year-old cars are now nervous.
Well, it's the 24-month period. Okay.
From the time the car is made.
From the time the car is purchased new. Okay.
Okay.
And it's all those vehicles that haven't. Well, let me tell you what takes it out of lemon law. Okay. If it's been involved in an accident. Okay. If it's a subject of neglect. Let's say there is a leak from the beginning and the oil leaks slowly. Well, if you don't take that in to correct it and as a result burn up the engine, that's due to neglect, not due to the underlying problem.
Yep.
If there's some sort of abuse involved, if you're, taking a little sedan off-roading every weekend or something like that, and if it's been modified or altered in any way, not by the manufacturer, not by the dealership.
What about a car that's new to me but still falls in that 2-year window of a new dealer sale?
Presumably, if it hadn't been subject to any of those things that takes it out, the accident, the neglect, abuse, modifications, or alterations, then it would be still covered under the lemon law, and you still have an opportunity to take it back to the manufacturer, the dealer, and give them an opportunity to correct it. And if they don't correct that same issue over 3 times, then it's subject to the lemon law.
Quick final question. What if I purchase from a third-party auto salesperson? Is that able to still go back to the manufacturer
of the car? As long as those interceding events haven't occurred, then yes.
Okay.
And you got to fill out a special form. The Florida Department has a website. It's myfloridalegal.com, and if you do /lemon law, you'll see the form. It's an official form. You present to them, put them on notice that you're declaring your car a lemon, that it's been the same issues been attempted to be fixed 3 times, or I've been without it for 15 days, and then they have 10 days to correct it. And if they don't, then they owe you your money back, or they have to replace it.
Okay, and we will put that website out on our website and social media as well, because boy, it's a lot of money to buy a car. If you're going to have problems, we want to get some help.
Especially at this holiday time, you see nothing but ads for cars and things, and so got to be protected.
All right, thanks for helping us. We appreciate it. For any information about your legal questions, go to injuriesarepersonal.com. We'll be right back with a holiday fashion show.